Okay, welcome everyone to today's Master Builders Build Better webinar series. Today we are going to look at the changes to the National Heavy Vehicle laws that are coming into effect this year. They mainly will talk about the chain of responsibility under the new laws and how it has a significant impact on the Australian construction industry because it shifts legal accountability beyond the drivers and to every party in the transport supply chain. This webinar will cover its effects on construction businesses, builders, contractors, including the broader legal duties and due diligence responsibilities under the Work Health and Safety Act. The Heavy Vehicle National Law Amendment Bill 2025 was passed in the Queensland Parliament in December last year. And the bottom line for the construction industry is a chain of responsibility means a greater shared accountability across that supply chain, the need for systematic compliance frameworks, policies, audits and digital tools, and a higher legal and financial risk for executives and business that fail to act. So if everyone can just ensure that you've got yourselves muted throughout Scott's presentation, that would be really appreciated. If you've got any questions, can you drop those into the chat? Sam's going to keep an eye on those and we'll get to as many of those as possible at the end of the presentation if we've got time. So on that note, I'd like to introduce Scott Knowles, who will be delivering today's webinar. Scott's from the National Heavy Vehicle Regulator and looks after New South Wales and ACT for the stakeholder engagement team. He's been with the NHVR for over 11 years, with 8 of those years working as an inspector in Victoria. Prior to joining Vic Roads Heavy Vehicle Regulator, Scott served in the Royal Australian Air Force as a police officer working in enforcement, counterintelligence and investigations fields across Australia, the Middle East and Southeast Asia. Scott will be speaking today about the primary duty and how your business may fall under this law, the new master code and how it relates to the chain of responsibility, and their heavy vehicle national laws changes coming into effect this year. So on that note, Scott, I'll hand it over to you.
Thank you very much, Lisa, and welcome to everyone joining us today. Thanks to MBA for the invitation. We are certainly ramping up a lot more communications with everybody in regards to the law changes and some other things. So there's good opportunity for us to get out and get to a wider audience. So I will be starting today with the primary duty, and we'll go through a couple of things about that. I will touch on the master code, SMS, which will be a new an extended version of the law if you are or want to go down the accreditation scheme for any vehicles. But for most of you guys, if you don't work directly with the trucks or have a trucking company, a lot of it around the safety management as well as COR will apply to you guys as well. So we'll get started. I'd like to throw in a couple of these fast facts that we give around internally, but we do allow you guys to have a look at these as well. It just shows a bit of a snippet as the what the NHVR do in the background. So obviously registered operators over 280 odd thousand. Our on-road guys, so if you do see our guys on the road with the weigh bridges, etc., they're conducting well over 5,000 intercepts a month. Cameras, as you will see, there's a lot of cameras around, especially in New South Wales. Over 6.5 or so million camera sightings that we filter through every month. It's quite a lot. As you see there as well, the road toll, we obviously watch that heavily. And we do have the data there showing 4 out of 5 accidents involving heavy vehicles and light vehicles. It is the light vehicles' fault. Unfortunately, I always tell people in these presentations that you won't see that on Channel 7 news. Unfortunately, it's usually the opposite. but we certainly supply that data. They have that data, but they choose not to put it on the news. So it's usually the big bad story with the truck's fault. So we'll step on to COR. So for anybody, COR is primary duty. That is ultimately what it's called in the law. COR sort of got tagged on the end of it. It is actually the parties in the chain that are called COR. So it's actually the primary duty that's in the law. So why chain of responsibility? So obviously once upon a time, drivers were responsible for everything that happened on the road, even through, even though they were little influence over what was actually being transported or where and when they were moving. So it became apparent that there needed to be a level of accountability created for everybody else, in addition to the driver who was responsible for influencing the way heavy vehicle journeys and tasks were undertaken. So obviously, again, that influence goes up the chain. Hence, the chain of responsibility concept was born and has been part of Australia road transport laws for more than 20 years. As much as a lot of people think that it's a new thing, it's actually been around quite a long time. So the term has come to mean a lot of different things, but broadly speaking, it's philosophy that recognises that keeping the public safe when a heavy vehicle is used on a road requires everybody to play their part. The term has also specific legal definitions under the HVNL. So what you need to know about COR, there are 10 defined parties, which you'll see on the screen, but 6 of them have nothing to do with owning or operating a truck. Instead, the definitions make you a party anytime you use a truck or move goods, meaning that most businesses in Australia would actually be part of the chain, even though the majority have never heard about COR or the HVNL. So very much like your DCs and etc. like that, big companies that ultimately push their stuff out, they don't own vehicles, they don't run vehicles, they really just see them when they're loading their product. A lot in the past have believed that they were not part of the chain, but obviously with more and more publicity and more education, they're realizing they are. So we're a party, you're a party because of the things your business does, which fit the definition, and you remain a party for the duration of the transport activity or journey or task, not just for the moment in time that you are packing or loading or scheduling. So you continue that duty. While COR partly defines or describes in terms of what a person does, the expectation is that the business which employs those people will take the lead on ensuring safety. This is because it is the business which is best placed to instruct how and why things are done. They employ the staff, they invest in training, they deploy other resources and necessary, and they're also the people that implement those systems. So no business here has an operating model where staff are staff are at liberty of to go or do whatever they want. So obviously within your business, you're not going to allow your staff just to run around and do as they want. You will have policies, you will have procedures in place, and that is all ultimately influenced by the business itself, not an individual. So while it's important to understand if you are a COR party, it isn't necessary critically to distinct on how many you are part. So out of those 10, you don't have to sit there and go through, I'm one of those, I'm a loader, I'm an operator, I'm an employer of drivers. Once you are actually part of one, you then have to look at the transport activities, and that's how you basically go through COR. So don't so much define yourself in multiple of these 10, once you define yourself as one, you are part of that chain. You now have a responsibility to make sure that all transport activities are done safely. So I suppose think about it like moving backwards through a funnel. Being a party is all you need to pass through the skinny part of that funnel, but the wide end represents your transport activities, the many and varied things your business does associated with the use of a heavy vehicle on a road. So being a prime contractor, which is on the list, isn't the same as being a principal contractor. A prime contractor engages a heavy vehicle driver or company under a contract of service. A principal contractor is a work health and safety term referred to the entity that top the multi-level construction tree or contracting tree. It does cause confusion sometimes. So being a loading manager isn't just about managing the load. It's about managing regular loading or unloading premises where 5 or more heavy vehicles are loaded or unloaded each day. So there are a little bit of definitions on some of these things. As much as it says loading manager, there is some things in the law that makes you a loading manager. So the key takeaways is important to always remember that COR is work that the business has to do in advance of a transport task being undertaken, not something that the driver is responsible for when they are out on the road. The point I would love you to take away from this whole session is that you need to or require to plan and prepare before. So all activities that are done by that driver is planned out. It's not up to the driver to solve any problem if something goes wrong technically on the road. There should already be systems in place. So I mentioned before that COR was around for more than 2 decades. The law changed significantly in 2018 and introduced what is now called the primary duty. Before then, COR was about parties being liable when a driver committed an offence. If a COR party was charged, then you would have to prove that you had taken reasonable steps to prevent that breach. And this is called the reasonable steps defence. It is no longer part of the law. The term reasonable steps is now a red flag technically to us. If you hear or see it used in relation to COR, we question whether the user knows what they are talking about, obviously in relation to the new primary duty. There is only one piece in the law where it still remains somewhat relevant, and that's within your executive due diligence. So CRR operating in this way is still a myth that we do hear, and it seems to be a reason why some businesses like to involve themselves very deeply in the way that another business partner runs their operation. So it's your operation that you run and you communicate with those others. So since 2018, instead of being liable as for the driver, it's now everybody within the chain, and that expanded to about 10 or so people, and now it's the responsibility of everybody to obviously let those vehicles on the road safely. This is pretty much only one of the bits that I put the law into so that you do know where to refer to, which is section 26C. This is the part where it obviously brings in so far as reasonably practical, safety and transport activity, and I'll touch on those in a sec. So 2 parts of the law, part A, which is the positive duty. There's a duty to eliminate public risk, or obviously if you can't eliminate, you need to minimize as much as possible. And obviously part B is that there is a duty to conduct, your conduct does not directly or indirectly cause someone to breach the law. There's a big example going around with time slotting. So a lot of the time slotting that DCs do, very much our investigators and others are looking into if that actually breaches the HVNL. So an example there would be obviously the DC requires 10 vehicles to be there at 2 a.m. in the morning. However, they can't provide that is 10 vehicles. They can only provide 9 because of fatigue. So then it's up to obviously there's a stage there where the business needs to ultimately say, no, I can only provide the 9. The DC has to abide by that as well. So they can't push that company to get 10 there because that would be breaching their part there. So the first definition is safety, very similar to work health and safety. It is all about that elimination, but it is about the public. Work health and safety tends to be about person and obviously not falling in a hole, etc. Whereas the part in our law is about the minimised risk or eliminating to the public. So it's that vehicle entering the roadway safely so that it does not put a risk to the public. Work health and safety again focuses on that individual person. So transport activities, very broad definition. It does take in everything to do with licensing, contracting agreements. We have added a broader definition into the master code, which I'll touch on a little bit later. What's that doing is basically allowing you guys to look at what kind of definitions we mean by transport activities, what areas it covers. So I'll give you some examples of transport. So these could be a bit left of stage sometimes. People don't realise that it actually becomes part of your transport activity. Some could be how you design or operate loading docks, for example, programming telematics systems or monitoring devices, cameras, etc. in the vehicles, how you recruit, hire or train or pay employees, how you make contracts and terms you include, how you plan loads of choice, the lashings you use, the equipment you use, etc., even down to like the plastic that you might put around your wood. So all of these and anything else your business does that relates to the use of the heavy vehicle on the road is part of your transport activities. And the primary duty requires you to carry out these activities in a way that keeps the public safe when the heavy vehicle is used on a road. So far as reasonably practical, it is obviously a court terminology. The courts would obviously consider the likelihood, the consequence, the knowledge, the solution and controls. The knowledge part, now that the new code of practice come out, the new master code, the knowledge would be implied that you have done your due diligence and look through that master code. So that would be knowledge about obviously risk controls, etc. And that master code can actually be used in a court. The courts will only consider the cost side of it if it's absolutely out of the scope. We're talking, spending millions of dollars on, say, a barrier or something like that. Other than that, the courts don't really determine cost if there is a liability of death or serious injury. So you obviously need to take that into account as well when it comes to COR. So I spoke a little bit about executive due diligence. So this is for your executives, directors, and managers. Now, the reason that those people are involved in the executive part of the law is that they have that control and influence, as I mentioned before. They can ultimately decide what happens within a business, and that's where I was saying before with COR or primary duty is ultimately the business. These people run the business. These people make the decisions in the business, so therefore they have the influence in that business. So they ultimately are held at a higher standard under this executive due diligence. So putting COR in practice. So understand your activities, including all the touch points with other parties and heavy vehicles themselves. Identify the hazards. So this is sounding very similar to work health and safety. Most businesses already have risk assessments in place. They have risk registers. Most may have a safety management system already. What we're saying is you just tag on to the end of that system, but it's to do with your transport activities. So we're not so much looking at the person and the risk. We're now looking at the transport activities and the risk associated with that. So if we put a load on the vehicle, what's the risk to that load? Could it fall off? Is it restrained properly? What sort of mitigations do we put in place? Have we got a risk that our drivers could be exposed to drugs or alcohol? Okay, that is now a risk. What sort of mitigations or steps do you put in place? So find reasonable practical measures to obviously control those risks and implement control measures throughout your business. That may be training, that may be equipment that's been used. As I said before, staff, so hiring the right people, communication between everybody, and the big one is reporting. So how do you report issues, especially to subcontractors or other parties in the chain? So 4 perspectives for managing safety. So we put this together as a bit of an example to show people how to start mapping out what you do. So, and as I said, for you companies that don't ultimately have transport as their forefront, so they might be a civil company and they subcontract to people, you still have to consider what you're doing with those heavy vehicles, what touch points you're going to have. Will they be unloading or loading on your property? Etc. like that. So obviously then you're going to have things that could come up as a risk. So thinking about it in a driver's terminology, the vehicles, ultimately the loads and the journeys. So when we talk about the journeys would be maps, routing, etc. like that. Your loads, how are you going to get the load off at the other end, which would may or change the fact of how they load it at part A. The vehicles. So if you are actually buying vehicles, you need to consider, are they fit for purpose? We've had plenty of people that like to come and whinge to us saying we need more weight on trucks. But when we actually ask more questions or go and visit them, we realize that they've actually bought the wrong vehicles. So a vehicle might be a 3-axle, but they should have bought a 4-axle twin steer, which then would have given that extra weight at the start. So it's just about researching and actually finding what is actually fit for your purpose. The driver's side of it. So very much we are in a driver's shortage and we fully understand that, but the law itself states that those drivers must be trained. Those drivers must have the right license. You know, are they in the right fit vehicle? Are they properly equipped? They're not fatigued, etc. And the big one is they're fit to drive. So how do we do that? So we now need to map those things and then we need to find those controls. This is an example that we give on our website and was part of the old code, was that mapping your transport for the effluent code or the livestock, is that just put that into a sort of terminology here where you can go through and map exactly what you do, where those touch points are with a heavy vehicle, and then put those mitigation controls in place. So that's just an example of sort of how someone within the livestock would map exactly what they do. So I'll move on to the code of practice. This has just been updated in January this year. It did go out to a lot of consultation within industry and other parties to get to where it is now. The old code was very much focused and emphasis on mass dimension loading, speed and fatigue. Now, pre-2018 or 2018 when the old code come in, it was brought in and written by the ATA and the ALC, and it was released shortly after the HVNL changed in 2018. So the primary duty was added to the law in 2018, part of the HVNL. So this had basically been part of that change. Unfortunately, it was very freight centric. It was difficult for people to read. It did repeat itself a lot as well. So it was old speech and old ways of thinking, because obviously the HVNL and primary duty had changed and come into effect. So it's been basically changed now into about 45 activities, and it's to obviously look at the breadth of the transport activities itself, as I was speaking before about. So it gives you a really in-depth part about, say, if I'm bringing someone into my yard, if I'm bringing new drivers in, what type of training, etc. So it very much breaks it down into those categories. I've broken it down here for everyone to see. So the 45 activities, it's broken up into 8 sort of main functions. So you're mapping the drivers, your vehicles, equipment, your journey planning, etc. like that. So if you haven't had a read of the new master code, please go and read it. As I said, it is taken as a knowledge base, so you should have knowledge of it. If the courts do refer to it and they ask you basically, have you seen it? No is not an answer in the court, unfortunately. It's now seen as something that you must know. So go in, break it down, have a look at the areas that are associated to you. You don't so much have to read the whole document. If you are someone that employs drivers, go and look at all the driving part, etc. like that. So the foundation activities been broken down again into these areas. It is relevant to every COR party, regardless of what activities you perform. So this is very much an area that everybody that has those touch points should be looking at. Any type of transport activity within your business, it means you do have that primary duty. And this part of the master code is something that you should know back to front. The other areas is obviously off-road parties, which was a big thing that didn't really come up in the old code. A lot of people that, like I say, do not ultimately own or run heavy vehicles didn't really have a part in the old code. So we have added a lot more to do with the off-road parties and how they can comply with their primary duty as well. There's also industry specific areas, so an example, shipping containers, livestock, etc. like that. So again, you can sort of really knuckle down to exactly the areas that you work in. Journey planning, very much the same. So there's 4 activities addressing the scheduling or functioning. Again, very big one that we see some issues with the scheduling side of it. A recent case that actually went through was an overseas scheduler that was doing work for a company in Australia. Obviously, they worked to different parameters overseas, but they didn't know or read or understand the primary duty, which they still played a part in. So that company was actually charged as well. So even though it was an overseas company, they were working on behalf of a company here in Australia. So the most common myths about COO is that it's a driver's responsibility. As I said before, that is the old law. It is way before 2018. So it is now the company's obligation. So the business should take the time to gather the information, make decisions, prepare the plans, provide instruction to those drivers about how to execute their job. So for drivers, the code provides an insight on how their employers should be doing the work. If a driver hasn't been trained on a piece of equipment or inducted into how to operate a vehicle, there is a failure on the part of the operator, and that's described in the code. So if a driver doesn't have good information about their load or how to restrain it or where the load is going, for an example, the failure is back on the COR parties. So the point of COO is to oblige other parties to do the things required to ensure safety and to make everything the driver's problem to solve. So it's not for the driver, as I said before, to actually solve a problem on the road. The company should have those steps in place already. There's a good saying, and I didn't really put the words that our COO advisor told us, but it's a not so good driver can equal a not so good operator. There is a lot of comments on social media about terrible drivers. In the end, it's not the driver, unfortunately, it's the operator or company. They have the control and influence over that person. If they're going to put that person in the seat, then that person should be fit to drive that vehicle in any respect. So basically, are the systems in place? Probably not. So just to break it up before I go on to the HVNL stuff, another little fact sheet I throw up, 1.1 million registered heavy vehicles in Australia. It's quite a lot. That's the breakdown there on the left. 30,000 PBS vehicles. So if you know a bit about PBS, there is a large number of vehicles in that system. And again, if you are part of the transport activities and you know all about permits, we go through about 16,000+ permits a month and applications coming through. That number is too high, and we'll be very honest about that. But working with over 500 road managers, which are mostly your local councils, can be very hard. So we are doing a lot of work in the background to start giving them more tools to actually do their job, make their job faster, so make their decisions faster, so that 16,000 does not grow. We are expecting that number will grow in the next few years to at least 300,000 a year. That's the prediction. We do not want to get there. That's just it's not sustainable. We want to get more roads on the network. We want to get more pre-approvals, if anything. There is a lot more technology coming into effect where these road managers and councils are getting the data, but it's again getting this data to them, and that is done through TCA. So it's not done ultimately through us, it's through another body. So again, we are working with transport authorities, both in ACT, New South Wales and around the state, as to try and expand a lot more networks. We get a lot of estates popping up, and obviously we need to start making sure that these roads around them are networked for certain vehicles to get in and out. That's very much where I sit and my team sits in working with these road managers to get that done. But as I said, to work with over 500 plus road managers, and alone, I think we have about 180 in New South Wales. Very lucky in the ACT, we only work with one, which is sometimes a little bit easier, but other times a bit harder. So the HVNL, now I don't have a huge amount. I'm going to touch on a bit of it through the SMS part of it. So so if I don't touch on it in these two slides, I will sort of touch a bit through the SMS side of it. So what's changing? So there is significant changes in the law, obviously coming into effect in July, and some other stuff will come in later in the year. So the replacement of the National Heavy Vehicle Accreditation Scheme is one. There will be now a new two-tiered system that will come into a place. So that's an alternate compliance accreditation and a general safety accreditation. And I'll explain a bit about that SMS shortly as to how you can apply for that. There will be changes to prescribed general access mass and length limits for combinations. Now, again, this is a very open-ended statement. Some vehicles will go to extended mass and extended lengths. Others may come later on. So an example is your 19-metre B double will more than likely come later on in the year. There's a bit of work being done. So at the moment, the NHVR has been given all the stuff from the NTC, and for those that sort of aren't all over the law side of it, the NTC, National Transport Commission, are the ones that did the review of the law. They're the ones that implement the law with the minister's approval. So the regulator is not the person that actually gets it all going and gets the review and changes the law. That is the NTC and the government. What we have been given by the NTC is now what we're working through. So we now have to work through the accreditation scheme they're giving us. Those two-tiered approaches have been given to us. So we're now working through that. The prescribed general access mass and dimension, again, has been given to us. So we need to work around with the jurisdictions, because obviously the jurisdictions are the road managers. We need to work with them to make sure that they're okay with the excess limits on the mass and also the length. So that work is very much towards the end of its phase at the moment. So we're just making sure that those jurisdictions are all good. The new duty not to drive whilst unfit to drive. This has again caused a little bit of rumours flying around. It is not based on the fatigue side of it, but it is very similar to the fatigue. So obviously not to drive a heavy vehicle fatigue is part of the fatigue laws. This unfit to drive will be for every heavy vehicle. So it is 4.5 tonne up, whereas your fatigue kicks in at 12. Now what that means is it gives more power to a driver to ultimately say no, that they are not fit to drive. So it starts bringing into effect not just the fatigue side of it, but your mental health, your physical health, and there's a few more that are actually included in that. So there is a lot of information coming out in regards to that, but it is not based on the fatigue side of it. It is based on the 4.5 tonne, obviously the limit of where the truck starts. There's changes to more than 70 penalties. Most of those will be in the fatigue space. So for an example, the work diary, for anyone that does use it or knows about it, that work diary will change. There is minor changes within how you fill it out, etc. That is currently into its final stages again, and it is going to ministerial approval. So there is what's called the ministerial approval document. That gives all the information as to what the NHVR have to work with, and that needs to be endorsed at different levels. So obviously the work that we have done in the background with changing the diary, with doing the fatigue management side of things, that then has to be signed off before then we can implement that stuff. The NTC has confirmed the 4 statutory instruments supporting the amendment have been endorsed by the steering committee. It is currently before ministers for that final approval. So again, we still don't have, I know one of my colleagues in the HVNL area, Paul Daly, he's the director of that area. He did a presentation where he very much said, we know 85%. but the 15 we're still waiting for. So we're working heavily through everything, but we still need that 15% from the ministers to actually finalise everything, which is why there might not be seen, or there might seem to be less information for industry at the moment. It's because it is totally ramping up. We're hoping that within the next month or two, you'll start seeing a lot more information coming out. Because obviously we need that final tick off. We don't want to come to you guys with half information. We want to make sure that it's been signed off, it's been approved, and we're giving you the actual information that will happen towards the mid-year when the implementation of the law happens. So what is the key areas that we're up to? So in the fatigue management space, we have working groups. Currently, the TCA and NHVR have partnered to do forums for our EWD, which is the electronic work diary, tech companies. They very much gave us a lot of good feedback back, so there is a few changes happening there. The vehicle access side, so obviously, as I said, we're working with the jurisdictions. That is heavily underway. The accreditation system, so we've been holding webinars with the auditors because obviously there is a new audit standard, which I'll touch on shortly. So we've been doing a lot of those webinars with those guys and again, getting really good feedback. There will be streamlined governance. So obviously the master code has already been released. The codes of practice will come into effect. There will be a very large campaign, communications campaign happening soon. And I will let Lisa and the guys know about a forum that we will be holding at the end of May in Sydney. So for anyone that wants to come up. The Euro 6 vehicles at this stage, I believe they have just got the approval this week to go into that mass and dimension changes. So again, this information will heavily come out shortly. So the safety management system, so this will be an obligation on all businesses if they want to go to the accreditation scheme. This is very much for companies that run under primary duty as well. We fully recommend that everybody that has a part under primary duty and the chain of responsibility should already have a safety management system because it certainly ticks those boxes as well. So it's one of the most effective ways of demonstrating how to meet your safety obligations under the law, and it's not a new concept. This has been around for a very long time. We actually have a lot of information on our website, and you can basically go through and build an SMS through the 9 steps on our website. So the HVNL reform will be introducing a new standard for auditors. It will be called the Safety Management System Standard, and it will not be an ISO 45001 for anyone that knows that one. So there will be a new standard. The standard shifts from focusing from providing a prescriptive requirement to being a performance-based. And operators will need to ensure they're not just achieving compliance, but they are actually focused on managing safety. So the new SMS standard, so this will be the new standard that will come through. So it's an outcomes-based SMS standard with clear evidence requirements. So the 5 components will be the leadership and commitment, so your guidance and vision, your risk management, so your hazards identification and your threat mitigation, the people side of it, so your training and awareness, your assurance and monitoring and improving, so it's that performance and feedback, as I was saying before, with different companies, and your safety systems, so those audit reviews and compliance standards. So that'll be the new framework of the new SMS, which again, very much relates back to that OH&S side of it. So how does the new standard compare to the existing? So it is the same concept, the same intent, but it is a different structure and it is scalable. So an example of that is I always give an example of the LIMFOX system. So a LIMFOX system might be a multi-million-dollar question or a multi-million-dollar system, but mum and dad run 2 trucks and their system needs to be scalable. They can't meet that LIMFOX multi-million-dollar system. So their system could simply be a filing cabinet in the corner with all their documents in that filing cabinet. So as long as they can show that they meet the standard, how they meet it is scalable to their business. So we do not expect those sort of tiny companies to be up with the big guys because they have the money to run those systems. So someone down the bottom, as I said, could easily have a filing cabinet as long as they can tick that their drivers are trained, themselves are trained, they're knowledgeable about the code, all that sort of thing. They know how to do their audits. If there's problems that arise with people that they're subcontracted to, they have a reporting system in place and you write it down. A good one our old lawyers used to say, if it's not written down, it didn't happen. Very much like that. You need to make sure that you record everything that happens within the business. If you turn up to a civils contracting site and they tell you to drive out overloaded, what are you going to do? What's your driver going to do? You need to have steps in place. So it is obviously, as I said, scalable to your operation size, the complexity, everything. Evaluated by auditors in accordance with that national standard, so that new standard. There will be new metrics for those auditors and for that standard as well. So the transition from what is now the heavy vehicle accreditation system to the new heavy vehicle accreditation. Now, the reason why we had to keep one name and then name it very similar is because during this, I don't think I've mentioned it, but I'll quickly mention it, is that there will be two laws, the current and the new, working side by side. As part of the accreditation scheme, the government and NTC have said that there will be a 3-year transitional period for anybody on accreditation now versus anybody on the new accreditation. So I'll touch on that a little bit shortly. So the tiered approach, the general safety accreditation, which is the overarching thing that everybody needs, and then the alternate compliance accreditation. SMS does become a core accreditation requirement. You must have an SMS if you wish to go into accreditation, and that is your mass maintenance fatigue. There is ministerial guidelines for heavy vehicle accreditation, and this is the part that's still under review. So until we get that fully signed, then we can actually start implementing things. The alternate accreditation will be for your fatigue, and it will replace the AFM and BFM. So for any companies running that situation, there will be no more BFM, AFM. Now, where that will continue is if your accreditation expires, say, in 2 years, you can still run on that BFM and accreditation, AFM accreditation until you expire. If you do expire this year, we are suggesting and we are contacting those companies to bring your accreditation forward and extend it for 2 years. So what that will do is you apply, basically you do your accreditation audit now, and it will allow you to get an extra 2 years, giving you that space to actually then roll over onto the new one. For businesses that already run AFM, have safety management systems in place, they've got everything working, those are the companies that will ultimately just roll over to the new system. So the alternate compliance accreditation will approve a bound by the outer limits for your fatigue. So whereas in the past you apply for BFM, which is 14 hours, AFM up to 15 or so, there is now what's called that outer limits, which is 15.5 hours, and you apply for anything in between those brackets. So the 12 hours standard to the 15.5. We are bringing out templates in regards to some sort of subsets to show you what you can do. So if you want to go to a normal AFM, how does that look? If you want to stay on your BFM, how does that look? So basically staying at those hours that you're normally doing. There will be mandatory risk assessments using the risk classification system as well. And again, it'll all focus down to that ministerial standard as well. So you need to read a couple things together to actually apply for this. This is this breakdown of what you see now compared to what you will see. As I said, these two will run together and side by side until the last accreditation falls, or 3 years. Basically, we are going to approve 2-year accreditation, which will be well within that 3 years. So the accreditation at the moment splits that fatigue to BFM, AFM. You have your maintenance, and then you'll have your mass accreditation, which is your CML, HML type style. With the general mass changing, there is obviously the possibility that GML will become CML. So there'll be no more CML. So if you do have accreditation for CML, you may not actually need accreditation in the future if all the vehicles are approved to go from general to CML. Under the new section, you'll notice there that there's a few more sort of areas that general safety accreditation is ultimately the first step to actually then trying to get anything else. You then have your alternate, which will be your mass and your fatigue. Your mass will just be your HML style. Your fatigue will be, as it shows there, just open. It is no more AFM or BFM. Your maintenance still has a place to a part there as well. Obviously in New South Wales, there's systems in place if you have that. So that is still there. It's a maintenance assurance program, which actually comes off the auditing standards as well. So definitely a few changes there. So to consider for operators that use this system, the processes that they currently have in place of what safety stuff do you do now and how it's documented. So your business plans, your operating models, your fatigue manuals, all this will play a part in getting the new accreditation. As I said there before, if you do want to reapply, if you are running out this year, you will be contacted. If you're not, please contact the NHVR in respect to the accreditation scheme. If not, contact your auditors. They should already know about this as well, and see if it's fit for your business to either extend your accreditation or to actually go on to the new one. And that's basically what I said there. So obviously we will be running a few forums as well throughout the year, especially leading up to July. As I said, I've got mine tentatively planned for the end of May in Sydney. So please just keep a lookout on our socials. I will put it through the associations as well, so you'll get it that way as well. That will be a lot closer to the implementation of the new laws, which will be in July or mid-year. So we will have a lot more information. Our full HVNL team and directors will be there. Our master code guys, I'm trying to get there as well. So very much they will have the in-depth information for you guys straight from their department as well. And that is it there. We'll pass it back to Lisa. I'll see if we've got any questions.
Thanks, Scott. That was great. Yes, I've got two questions here from Adam. The first one was in relation to the outline that you provided, that it's no longer required to have a primary breach or incident for primary duties to exist. And of the prosecutions for incidents after the 1st of October 2018, what proportion of those did not relate to an incident or a primary breach?
Hard one to say there, Adam. Sorry, I don't have stats in front of me. It was a large myth, I suppose, in the past for everybody else. I'm sure Adam knows, but in the past, a lot didn't realize that you couldn't, or if there was no incident, that you could still be prosecuted. The past was obviously the old law come in where it was about that reasonable steps defence. If a driver did commit an offence, you would have to prove that you were not part of that. In 2018, that went the opposite way. So you now actually have to have those positive primary duties, so those positive steps, very similar, if not the same as work health and safety. So you need to put something in place to stop someone doing something silly. That's ultimately the thing there. In respect to incidents, again, it does not have to occur. You do not have to crash a truck. You do not have to have a load come off for a prosecution to occur. Tomorrow, our investigators could walk in and ask you, have you got all your documents for fatigue? Have you got all your documents for mass awareness, training documents, everything? How have you proven, or where's the evidence for you to show that you are putting those vehicles on the road safely? Now, if you don't own those vehicles, how are you communicating what steps you have in place as a primary contractor or as a ultimately the person up the top of the chain? What sort of things have you put in place to work with your transport companies, your subcontractors, etc.? We find it a lot in Sydney at the moment where a lot of companies, civil companies especially, hire a prime contractor, so a main transport company, and they need 200 trucks. Now that company only has 100 or so they need to go out to subbies. So they go to the subby, the next one only has 40 trucks, so he goes to another subby which has 20. So we all of a sudden get all these multiple of subbies working for this primary person. What needs to happen for that primary person, everybody down the train, is that ultimately they need to all communicate. So that primary person has to make sure that everything's in place. What sort of communications he has with the first transport company. If the first transport company subcontract, what sort of things do they have in place? Ultimately, you need to make sure that all those vehicles enter the road safely. How you do that, how you meet that primary duty is up to your business. They control and influence everybody below, which is basically what I've spoke about there. In regards to stats, I do not have stats in front of me to work that one out, Adam.
Thanks, Scott. And then the next question was, you mentioned that the current COR legislation came into effect on the 1st of October 2018, which is roughly 7.5 years ago. Has it worked? And if so, how is that measured and defined? And then if not, why not?
Yeah, so has it been effective? I think if you look at a situation, an example, one of our past COR advisors that did a lot of executive stuff, she used to give a case study of the Connect Logistics vehicle. For those that don't know, it's the one that ultimately killed the 4 police officers in Victoria. That worked in the way that it went up the chain to find the problem. That driver could have easily been stopped many months before. The amount of offences, 800 plus, the company knew of over 500 of those. The company ultimately knew that the driver was on methamphetamines on the day. So there's a lot of things that should have happened but didn't happen because it stopped up the chain. So the directors were ultimately charged because they were the ones ultimately that should have known about stuff happening in their business. But what happened is in the middle, that person went a bit rogue. So there was no communication up, no communication down, etc. So those laws obviously were into effect and showed that all the way up to directors, including managers, including the state operations people, were all liable for that accident. Yes, the driver was on meth. Yes, he chose to do that. But ultimately, the company knew of so much before that was happening that that driver shouldn't have been on the road. So I think with the laws changed where a driver caused an incident or had an incident, then we come in and said, right, what ultimately did you do to try to stop that? With the new laws, it is ultimately what have you done before something happens? So what steps have you taken? What policies, procedures have you put in place for that vehicle to enter the road safely, for that driver to enter the road safely, not wait till something happens? So I think that ultimately shows that, yes, it works in the way that we are looking up the chain and taking that responsibility off the driver who ultimately doesn't have that influence over how things work.
Thanks, Scott. Adam, I think Scott's answered your questions. I'm sure you can reach out to him if you want to delve into that a bit more. I've got one more question for you, Scott, from Luke. In relation to the New South Wales SMS standard, there was a point relating to a focus on public risk rather than work health and safety. Are you able to provide some examples relating to the public risk and improving the SMS standards about that focus?
Yeah, so it's firstly it's not New South Wales standard, it is the Australian standard. So when it comes to public risk, as I was saying, you've got to take it away from the individual itself, which is what work health and safety covers. It covers the individual for workplace incidents, etc. So you're putting something in place for someone not to trip over a cord, for not to fall in a hole, so you put a barrier around it. So you're ultimately trying to put risk mitigations in place for those people. When it comes to public risk, we're talking about public risk to infrastructure, public risk to other road users, vulnerable road users, cyclists, pedestrians, everybody. So when we put a truck on the road, we need to know that that truck is safe to go on the road. So is it roadworthy? Is the maintenance up to standard? Is the load tied on? Because if it comes off, it could ultimately fall on someone. Is the driver fit to be in that vehicle? So when we talk about public risk, we talk about not just a public risk to the person, we talk about everything, the environmental factors. So, we're talking about fuel that could come out, etc., into the waterways, etc. So when it comes to public risk, as I said, you need to take it away from an individual factor. You need to then relate it back to the environmental factor, the people out there actually in the environment, in the streets, other road users, etc. like that. So it's everybody else. So it's not that individual factor of what work health and safety focuses on.
Excellent. Thank you for that. I think Luke just gave you the thumbs up. So thank you again for putting this presentation together, Scott. There's some really great information in there which we can all take away. I think the key takeaways for the industry and for those operating in the industry that aren't directly involved with the heavy vehicle transport, they now have to give a bit more consideration to whether they're operating with vehicles over that 4.5 tonne and the impact that that chain of responsibility has for them, as well as directly with their workers. We also need to ensure that in our planning and preparing, when we're ordering our supplies, our materials, our precast concrete panels, that we're having that communication with the suppliers of those in relation to that load, the securing the loads and ensuring the loads are going to come off the way they need to come off at the other end once they get to the construction sites, as an example. And ensure that all of our transport activities that we're involved in the planning and the contracting and the engaging of our subcontractors and our suppliers, that we're identifying the risks and ensuring that that's in our safety management systems that we have and part of our risk management plan, so that we're identifying those touch points and ensuring that as far as we can, as reasonably practical, we can put control measures in place in our systems to ensure the safety that we're all trying to achieve. So thank you again, Scott. Thank you everyone for taking the time out to be a part of this webinar. And yeah, thanks to everyone for attending, and stay safe, stay tuned. I'm sure we'll have more information coming out to you all in relation to the heavy vehicle laws, and Scott and I will stay in contact and make sure that you've all got the most up-to-date information that you need.
Thank you very much, everyone.
Thanks.